Well, hi, and thank you for joining us. I'm Emily Myers, a writer at Brick Underground. I've been covering real estate in New York City for close to 5 years. I'm very excited to be hosting our first Brick Underground Q&A to give you the opportunity to get answers to all your New York City tenants' rights questions. A word of housekeeping and just a reminder that, of course, we are switching off video and we will have you on mute, but please do put your questions in the chat. Well, of course, renting in New York City requires a big financial commitment. And then comes some of the frustrating issues you face as a tenant, whether that's a broken elevator or a substantial rent increase when you go to renew. Well, Brick's goal is to make life easier for you, empowering you with knowledge about your rights as a tenant and helping you meet your housing goals. So to answer your questions, I'm thrilled to introduce tenant attorney Sam Himmelstein, a partner at Himmelstein, McConnell, Gribben Joseph, who represents residential and commercial tenants and tenant associations. Sam, hi.
Hi, how are you? Good to be here.
It's great to have you here. And I am just going to make sure that your details are in the chat as well. Of course, Sam, you are also Brick Underground's Ask a Renters' Rights lawyer, columnist, and a long-time Brick sponsor. I think it would take me a very long time to list all your achievements, but let's just say they are many. We have set aside 30 minutes for this Q&A, although it may run over that time. And I want to make sure we get to as many questions as possible. We did poll people ahead of time, and we do have some questions to get going. So perhaps we can jump straight in with the first one, which is about water temperature. A reader says, the water in my kitchen sink is only lukewarm, never hot. I've complained several times over the last 6 months and nothing has happened. Can I ask for a rent abatement? Also, if I complain again, can they raise my rent even more in retaliation when I re-sign my lease? And they add, I'm in a luxury building. Sam, what's your advice here?
Well, let's start with this. First of all, the person asking the question is probably not a rent stabilized tenant. And a lot of the answers I'm going to be giving today are going to distinguish between the rights of a stabilized and non-stabilized tenant. Everybody in New York City, in New York State, has the right to a habitable apartment. There is something called the warranty of habitability that covers every single apartment. It essentially says that apartments have to be free of conditions dangerous to life, health, and safety, but that is very, very broadly construed. So not having hot water would be considered a breach of the warranty of habitability. There is also a minimum temperature required for hot water. Unfortunately, I don't know it off the top of my head, but it is in the New York City Housing and Maintenance Code. So if you're not getting hot water, yes, you should be entitled to a rent abatement. How much? Very hard to tell. 15%, 20%, somewhere in that range, because, it affects your ability to shower and shave and do all those other things. But if you complain, while New York State has these wonderful laws that prohibit retaliation and that prohibit a landlord from not renewing a lease or evicting a tenant in retaliation for their complaining, or even raising the rent unconscionably in retaliation, I have found that enforcing a retaliatory eviction case is very, very difficult in court. It's very, very hard to prove, even though the law creates a presumption that if within 6 months of a complaint, the landlord acts in a retaliatory manner, it's still very hard to prove. And what you get out of it, in other words, let's say the landlord refuses to renew the lease or raises the rent to some amount you don't want to pay, and you end up in court and you defend the case based on retaliatory eviction. If you win, all you get is a 1-year lease. And at the end of that 1-year lease, the landlord's retaliatory motive is deemed to have been purged, is the word. So why fight? Why pay a lawyer? Why spend thousands of dollars? Why spend hours in court fighting for something that's only going to get you another year in the apartment? One other, I guess, piece of advice here. This is the kind of issue that it's better to respond with numbers. So if this is affecting other tenants in the building, as a problem with hot water typically would, get a few of your neighbors together and deal with it collectively. It makes you much harder to be picked off that way.
Okay, so that's actually really good advice for other issues or in the building, to kind of get moral support from your neighbors.
Now, if this person were stabilized, then they wouldn't have to worry about retaliation in the sense of they would still have to have their lease renewed. They couldn't have their rent increased beyond what rent stabilization allows. And so this is a perfect example of how a stabilized tenant can be much more confident in enforcing their rights than a non-stabilized tenant.
Because in a rent stabilized situation, your renewal is guaranteed. Yeah, that's
correct. And you can, yes, you at a very modest increase, whatever the current guidelines are. So it's much safer if you're a stabilized tenant to complain about conditions.
Okay. Well, actually, we do have a question about someone in a rent stabilized apartment reaching out with a question. This is about late rent payments. This tenant mails their check to the landlord and says the original lease doesn't have a clause about late payments. They notice they are being charged a late fee. And they've also seen late charges applied for backdated rent payments totaling thousands of dollars. And they ask, are we responsible for the late fees if we were never told about what constitutes a late payment and it's not in the lease? I know that late payments were addressed in the rent reforms in 2019.
Right. So this one's easy. One of the fundamental tenets of rent stabilization is that renewal leases must be on the same terms and conditions as the original lease. And if you have a copy of your original lease, or this particular person, it sounds like they do, and there is not a late fee clause, it cannot be imposed subsequently. And so all those late fees are illegal, and the tenant does not have to pay them. And if the landlord tried to enforce them, they'd be thrown out of court. What the rent reform laws did was simply, they didn't outlaw late fees, which would otherwise be permissible. But what they said is they can't be collected as if they were rent, meaning if you don't pay your rent, you could potentially be evicted. But if you're a stabilized tenant, but if you don't pay late fees, that cannot be the basis for your eviction. But in this case, since this person appears to have their original lease, and it does not have a late fee clause, they're completely within their rights in not paying those fees, and the landlord can impose them.
Okay. But this obviously, I think we've got a question. Does the same apply for market rate tenants?
No. Market rate leases, well, what does apply is what I said about it can't be used to evict you. It's still that applies to all tenancies.
Yeah.
But late fees are permissible in market rate leases. And if you have an original lease that doesn't have a late fee clause, but the landlord puts it in a renewal lease, and if you agree to it, it is enforceable.
Right.
It can't be unconscionable. It can't be exorbitant. It can't be a $500 late fee on a $3,000 rent. It has to be reasonably related to the harm that the landlord is suffering as a result of the rent being paid late, because late fees are what we call a liquidated damages clause. In other words, the landlord is saying, I've somehow been harmed by your paying this late. It's hard exactly to quantify, but they can't, a late fee of $25, $50 is probably okay.
I thought late fees were actually capped at $50, but
I don't think so. But I can look into that, but I don't think so. Maybe you're right. You mean the new law capped them at $50?
I believe the 2019 law changed.
I've never confronted that issue, so I don't know the answer, but it could be. Yeah,
we'll have a look into that.
Yeah.
Actually, we have this scenario presented to us by a brick reader, and this is again a rent stabilized apartment. A 35-year-old has been living with their mother in a rent stabilized apartment and is an occupant on the lease. Can they take on the lease if their mother moves out? It looks like the landlord is advising them to stay as an occupant right now, not a signatory on the lease. So what are the issues that you should be thinking about in terms of taking on a rent stabilized lease?
Okay, so there's a concept under rent stabilization, which is called succession. If a family member co-occupies an apartment with a rent stabilized tenant for 2 years prior to the date that tenant permanently vacates the apartment. Permanent vacating means either the tenant has died, or they have moved into a nursing home and they're never coming back, or they simply move out. They go to Florida or they move to another apartment. If a family member has been co-occupying the apartment for that 2-year period, and the apartment was the primary residence of both the tenant and the family member, that family member can take over the tenancy under what is called succession. That 2-year period is shortened to 1 year if the successor is 62 or over or is disabled. And the definition of family, it's basically children, parents, grandchildren, grandparents, brothers, sisters, husbands, wives. Aunts and uncles and nieces and nephews were eliminated in 1997. But there's also a category of family members, which is if you have an emotionally and financially interdependent relationship with the tenant, even if you're not related by blood or marriage, you can also succeed to the tenancy. People often ask me, well, I'm the child or the grandchild. Why can't I just be added to the lease? Why do I have to go through this whole succession issue? And the reason is that landlords are not required to add any family members to an existing lease other than a spouse. So if you get married, you have a right to be added to the lease. And I recommend that people do that, because then they don't have to go through the succession request if and when one of the spouses leaves. But in terms of this particular situation with the child, if the landlord doesn't want to add them as a tenant to the lease, there's no way to force it.
But it sounds like, from what you're saying, the succession rules would apply.
Yes, based on what's described there, that both the tenant and the family member are living together. The problem is, when you have a situation like this, I hate to be morbid about this, but you never know when the tenant is going to die. And if let's say you're an adult child, you have to, the only 2 years that count are the 2 years immediately preceding the date that the tenant vacates. So you basically have two scenarios. One where the vacating is planned because the tenant knows, okay, I bought a condo in Florida and I'm moving. But the other is when it's health related. And, I've had many, many cases over the years where family members moved in, but the tenant died before they reached the 2 years of co-occupancy. In some cases, only a month short, and the tenants couldn't prevail. Unfortunately, the 2 years is a very strict cutoff.
Wow. And I think I'm right in saying this is consistent with Mitchell-Lama buildings as well.
Yes, correct. And there's one other exception I should mention to the 2-year rule, which is if there's co-occupancy from the inception of the relationship or the inception of the tenancy, then the 2 years doesn't apply. So in other words, if a husband and wife move in, get married, and the husband, say, moves into the apartment and the wife dies a year later, he would still have succession rights because he lived there from the inception of the relationship.
Right. Okay. Well, it looks like we have a question in the chat about flooring in a rent-controlled apartment. Ellen says that the previous tenant put down carpeting and it's slowly being worn away. The wood floors under the carpeting have never been treated. So raw wood under this on the floor. Can I get the landlord to do anything with the floors since the carpeting's coming off and splinters are?
I mean, it sounds to me like the carpeting is defective, and carpeting that's wearing like that could not only is not only unsightly and a cosmetic problem, it could potentially be dangerous. Carpeting is considered cosmetic. The tenant has every right to take up the carpeting unless the lease requires the apartment to be carpeted. Some leases have clauses in them that say that 80% of the apartment has to be carpeted. And that probably is an enforceable clause. If there is no such clause in the lease, the tenant has a right to take up the carpeting. And then I think it would depend on whether the damage to the floors, again, is cosmetic or is actually something that needs repair. So, for example, if it's just stained, that might be the tenant's responsibility. But if there's splintering, if there's floorboards that are coming up, if there's nails that are coming up, things like that, it's definitely the landlord's responsibility under the warranty of habitability.
Yeah, exactly. Providing a safe and habitable place. Okay, I hope that's answered the question. We did get another question before the Q&A. This is about cleaning. Are landlords required to clean, either mop or sweep apartment building hallways on a regular basis? So this is the common areas. And for some context, the tenant says, I live in a brownstone with 13 apartments and the management company just changed. The previous company used to mop every week and now it's happening once a month, which doesn't seem adequate for a high traffic building. Sam, what are a landlord's obligations when it comes to the common areas of a building?
They have to be kept clean and sanitary. And again, let's distinguish between stabilization and not. Rent stabilization has a concept called required services. Essentially, it means that any service that you're being provided when you move into a rent stabilized apartment must be continued. It could be a doorman, it could be a laundry room, it could be a storage area, or it could be the frequency of which the common areas are cleaned. And if it used to be once a week and this tenant is stabilized and now it's once a month, coupled with the fact that the floors are dirtier, the tenant can file a reduction of services complaint at the DHCR, Division of Housing and Community Renewal, and they will send out an inspector. And if they find that there is a reduction of services, they will roll the tenant's rent back to what it was being paid in the prior lease, and it will be frozen there until the problem is rectified. And that's the kind of thing, if there are stabilized tenants in the building, it's much better to band together and get a building-wide reduction of services because it'll have a greater economic impact on the landlord. It means they can't even raise the rent if a tenant moves out. There's no increases at all. So that's what we recommend. In a non-rent stabilized situation, it really comes down to whether the lack of cleaning creates unsanitary conditions. If it does, then it's a borderline warranty of habitability issue. But again, everything I said before about retaliation and renewal leases would apply you got to be careful about the battles that you pick as a non-regulated tenant, because landlords might retaliate by saying, this person's not is too much of a pain in the what, and I don't want them there anymore. And so everything I then said about retaliation applies.
And is there any sort of practical advice then about that? I mean, do you just advise, picking your battles? Is that
you got to me, having the floors clean is important, but to me, it's not the most important. It wouldn't be the most important issue for me. I understand, I'm not there. I don't know how dirty the floors are, I don't know. I just don't know whether that would be the battle I would pick if I were a market rate tenant.
Sure. And would it be sensible to document the condition? I mean,
always, whenever we're going to be talking about conditions, it's important that communications be put in writing, that you not rely on, calling the landlord and verbally complaining. Emails are fine. It doesn't have to be a formal certified letter. And photographing is important, so that you have proof of the condition.
Okay. Another question we got ahead of time was about the super. The super in our building is unpleasant towards tenants, and many of us have complained, but nothing is done about it.
Right.
What can we do? And I think there is a question. Does Ellen have a follow-up about the super in her building? Complaints about supers. How can that be dealt with?
You can't legislate courtesy, unfortunately. So if the super is simply being discourteous and doesn't say thank you and doesn't smile and grunts when you speak to him, I don't think there's much you can do about it. However, there's sort of a fine line between discourteousness and it rising to the level of harassment, right? New York's, among the things that the changes in the 2019 laws did was they greatly strengthened the anti-harassment provisions in New York. Now all tenants can file harassment complaints in housing court, which did not exist before 2019. Before 2019, the only tenants who could file harassment complaints were rent-regulated tenants. Now anyone can file a harassment case in what is called the HP part in housing court, which is the part that adjudicates HP proceedings, which are proceedings to get repairs done. And we've seen some pretty incredible decisions coming out of housing court where landlords were ordered to stop harassing, and in some cases were actually fined. I don't know what the specifics are, and it's hard for me to, opine on whether or not what this particular super is doing constitutes harassment. But I have been involved in several of these cases over the years, including one that always is very memorable, where the superintendent, I had 3 tenants who were all women, and the superintendent was, when they were away, would enter their apartment and go through their personal possessions. And they caught him on camera. They installed a nanny cam in their apartment. That's clearly harassment. I didn't have to do very much to get that superintendent fired. This sounds more like it's closer to just discourteousness, and I'm not sure how much can be done about it.
Okay. We have this question in the chat. What strategy would you use if a tenant lives in a rent stabilized apartment and is experiencing severe mold issues?
Oh.
Mold is a violation of the warranty of habitability, isn't it? So
yes.
Your advice there. Mold
is a big part of my practice. It's very, very common. It comes about from persistent unattended to leaks, where the walls or floors or ceilings are moist for long periods of time, and they build up mold. And we have at our firm a very, very specific way of dealing with these cases. So it's essential to get a expert in, a mold remediation company, a knowledgeable, reputable company to come in and do mold testing, because your observation of the mold doesn't mean very much in court. And if you call HPD, which is the Department of Housing Preservation and Development, and you complain about mold, they will send an inspector, but only if there's visible mold will they place a violation, and they won't discuss the extent of it or the type of the mold. They don't do testing. What an environmental expert will do is take air samples and scrapings, send them off to a lab, will tell you the type of mold that is in the walls and ceilings, whether it's dangerous, how extensive it is, and will also recommend a mold remediation plan that complies with the Department of Health guidelines. The Department of Health has guidelines as to how mold has to be remediated. Unfortunately, they're just guidelines. And what very often happens in these cases is that we write to the landlord and we insist that the mold be remediated. Again, everything comes down to money. The landlord wants to go in and spray some bleach on it, and we're insisting that they retain a mold remediation company, a licensed company, to do the remediation, and then hire a third company to do post-remediation testing, which is required by the Department of Health guidelines. And these cases often end up in the HP part of housing court. And what we grapple with, and I can't tell you that it's completely resolved, is trying to convince the judge in the HP part that the mold remediation has to be done the way our expert says, or whether the landlord can just do it the way they want. And if it doesn't address the problem, you have to come back. And that is an unresolved issue, unfortunately, at this time. If some city agency could see fit to making these guidelines from the Department of Health mandatory, it would solve the problem. But the thing I want to emphasize is that you have to hire an expert. I guess I'm not supposed to make recommendations here, but there is a company that we use, that I've been using for 25 years, that is far and away the best. And if anyone wants to contact me, online, send me an email, I'll be happy to provide it to you.
Yeah, I mean, do you advise using a license, presumably making sure that they're licensed is the first step?
They're certified mold inspectors, yes. But there's one company that in New York that likes working with tenants and is very, very well recognized in the courts and always qualified as an expert. And it's the only company we use. So again, if people have this issue and they want to send me an email, I'll be happy to give you that information.
Great. So actually, we have another question. For a rent stabilized building, the current lease says no smoking or pets allowed, but the original lease from 55 years ago never said that. So do I have the right to have a pet or to smoke? Is that allowed? And he asks also, what about a support animal? Well, obviously there are different rules with support animals. So perhaps you can just address whether a lease, you're in a rent stabilized building, and if the lease doesn't address smoking or pets.
Right. So yeah, if the original lease did not restrict pets or smoking, you can have a pet and you can smoke in your apartment. And if the landlord were to try to evict you for having the pet, you'd win the case because of that original lease. If the original lease contained a no pet clause and was then renewed, that clause would project. If you then get a pet, New York has a law that says that if the landlord finds out about the pet and doesn't take any steps for 3 months after obtaining that knowledge, then they can't enforce the clause. And the the issue of how they obtain that knowledge is very broadly construed. So it means if the super saw the dog, or if the doorman saw the dog when the tenant walks it at night, that knowledge is imputed to the landlord. And from that first encounter, after the passage of 3 months, that dog is protected. It would not protect a subsequent dog. In other words, the 3 months would start running every time you get a new pet. Emotional support animals are an exception. If you have a bona fide need for an emotional support animal, you have a diagnosis from a social worker or a psychologist or a psychiatrist, you have a right to have a pet despite what the clause says. And I have yet to see a landlord fight a claim of an emotional support animal. It's almost an impossible case for them to win, because the courts generally don't want to get involved in doing a psychiatric examination of the tenant to see if they really need one. So now the smoking issue is a different issue. This comes up a lot. Again, the same rules apply with the lease. If there's nothing in the lease, the original lease, then yes, you can smoke. Buildings are now required to have smoking policies. Some buildings are considered no smoking anywhere in apartments, anywhere in the hallways. However, those rules can't be imposed on rent stabilized tenants who, again, don't have a no smoking paragraph. Now, what happens in these cases is that very often a tenant is smoking and the neighbors are complaining. The neighbors say the smoke is traveling from that apartment to mine. My kids have asthma. It's aggravating their asthma. I'm not unsympathetic, but what the law requires in that situation is that the landlord takes steps to stop the smoke from traveling from one apartment to another, either by installing some kind of negative airflow or something like that. And frankly, when I have clients in that situation who are the smokers, I urge them to take steps also to, get some kind. There are devices that, will suck the smoke out the window and things like that. And I urge them to do that just to respect their neighbor's health, So, but again, you're allowed to smoke if there's no clause in that original lease.
Interesting. Okay. Well, we have just a bit more time. So Sandy asks, I am renting a 1-bedroom condo in Turtle Bay for $4,000. Last September, the gas in the building was turned off, so I haven't had a stove or an oven. In December, they shut down the dryers, supposedly for 30 days, but now they're saying it's delayed until September. Can I negotiate the rent at renewal time? I think we'd say always negotiate at renewal time. I mean, success isn't guaranteed. You can always try. How would you advise, Sandy? Yeah.
Again, another incredibly common problem in New York City right now. And as with many problems, I don't know if you remember, but a few years ago, there were some very well publicized gas explosions in New York City. And after that, the utility companies and the buildings department cracked down on gas issues. And now whenever there's a gas leak, they come in and they inspect all the pipes in the building. And if there is a single leak anywhere, they shut down the gas. And very often it takes weeks, months to get the gas back on. So as a rule of thumb, when a tenant doesn't have gas, they are generally entitled to an abatement of somewhere between 10 and 20%. More if it affects, if they have a dryer and a stove, less if it's just a stove. Is it worth going to housing court over that? I'm not sure. You would have to withhold rent. The landlord would sue you. You'd ask the judge for an abatement. On the other hand, when tenants band together in these situations, again, the issue of forming a tenant association, and approach the landlord and say, look, we have no gas, landlords will generally agree to an abatement in that range until the gas is restored, in almost all cases, in my experience. So yes, you should try to negotiate an abatement. And as you said, when renewal time comes, you should always negotiate, but that would be a kind of a chip on your side of the bargaining table, because if what I would say to the landlord if I were the tenant is, look, if I move, you're not going to be able to re-rent this apartment because no one is going to rent an apartment with no gas. So I'm all you got. So, unless you're going to reduce my rent by 15 or 20%, I'm going to leave. And then the landlord is going to have no rent on the apartment. So that's how I would approach that negotiation.
Great. That's good practical advice. Actually, I think we had one follow-up questions on supers. Do buildings over a certain amount of apartments have to have a live-in super? Are there
well, I wish I memorized this. It's either 11 or 13, I believe. And if it's that number or over, there has to be a super in the building or within, I think it's 200 feet of the building. Those are roughly the numbers. I think if you just Google it, that's how we all do legal research, by the way, these days. If you just Google it and say, does my building have to have a superintendent in New York City, it'll pop right up. But the numbers are somewhere in that range.
Oh, you can always go to Brick Underground as well, because
there you go.
Probably covered it somewhere in our
right.
coverage. So, okay, that's interesting. We had Marjorie wants to know, this is a little bit broader, less sort of specific. How has the pandemic and the new rent laws affected the frequency and amount of tenant buyouts?
Very interesting question. So just a little background. In 2019, the New York State Legislature passed the Housing Stability Tenant Protection Act, or as we call it in the tenant community, HISPA. And HISPA, experts have looked at HISPA. HISPA was the most sweeping change in a state's landlord-tenant laws that went all in favor of the tenants in the history of the United States. It changed everything. Perhaps the major change, though the most important one, was that it outlawed vacancy destabilization and high income destabilization. So what that means is that in 1993, under the Pataki administration, until 2019, landlords who were able to legally raise the rent of a rent stabilized apartment above a certain threshold could then deregulate the apartment and charge market rates. So that 3-bedroom Upper West Side apartment that was renting for $2,200 a month is suddenly going for $8,000 or $10,000 a month. And hundreds of thousands of apartments in New York State were deregulated. That no longer exists. When a rent stabilized apartment becomes vacant now, unless it's in a co-op or a condo, the landlord cannot destabilize it. And the most they can raise the rent, even if they renovate it, is $89 a month. So why would any landlord in his right mind buy a tenant out under those circumstances? What used to fuel these buyouts was the fact that if the landlord got that tenant out of that apartment, they would immediately see a multi-$1,000 increase. And whatever they paid that tenant, they'd make back in 3 years or 5 years or 6 years. That doesn't exist anymore. So the number of buyouts that I see in my practice has drastically decreased. I still see them in co-op and condo situations, because if you're a rent stabilized tenant in a building that is converted to co-op or condominium, even though you're still stabilized, the minute you vacate, that apartment is deregulated and the landlord can sell it or rent it at market. So that's one situation we see them. And the other is where the landlord can turn the apartment into what we call a Frankenstein apartment. Maybe some of you have heard this phrase. This is when the landlord combines the apartment with an apartment nearby and creates a larger apartment, or chops the apartment up into smaller apartments. And under current law, they can then charge what is called a first rent for that newly created apartment or apartments. First rent meaning whatever the market will bear, whatever the next tenant is willing to pay, but then the apartment goes back into rent stabilization. So in those situations, we're still seeing some buyouts. However, there is legislation pending which would outlaw Frankensteining, and the DHCR is considering outlawing the practice as well. So landlords are a little bit queasy now about doing buyouts in those situations because they're afraid that the law will change and they won't be able to do what they planned. The other thing is that landlords are, you've probably read about, many of you have probably read about this, landlords are warehousing apartments throughout the city in the hope, I think, that somehow the legislature is going to cut back on some of these rules. And there is also a case that may make its way to the Supreme Court, which is challenging a lot of the provisions of HISPA, including the ban on deregulation. And that case lost in the lower court and is, making its way up. We don't know if the Supreme Court will take it. And, some of us are a little bit nervous about what this Supreme Court might do with that case. So I think some landlords are just leaving their apartments vacant in the hopes that they get some relief from the courts or the legislature.
Yes, we've certainly written about warehousing. But actually, one important question, I think, for New Yorkers is, how do you check if your apartment is rent stabilized? Because I know that you deal with a lot with illegally deregulated apartments. Is there an easy step process to check that whether your apartment is rent stabilized?
There is, but the way you check is you get the apartment registration history from the Division of Housing and Community Renewal. So landlords are required to annually register rent stabilized apartments. So if you obtain this history, you'll be able to see how long the apartment was stabilized, what the rent was, when it allegedly became destabilized, what the rent was at that point, what the threshold was at that point that the landlord needed to get to in order to destabilize. Unfortunately, you probably need to bring that information to a lawyer. But here's the difficulty. The DHCR will not give anyone who walks off the street the rent history for an apartment. They have to prove that they're connected somehow to the apartment. You have to produce either a lease or a utility bill or a rent bill or some other document to show that you are the tenant or an occupant of that apartment. So if you're not in it yet, it's very hard to get that information. And it used to be, if you had that information, you could walk into one of their offices and get it. Since the pandemic, they've made it harder to do that. And what they prefer to do is simply mail the information to the apartment in question. But if you're not yet in that apartment, you're not going to get that mail. So I guess the best thing to try to do would be to bring, in other words, let's say you have a piece of paper from a broker, or let's say the landlord has agreed to rent you the apartment and has sent you the lease to look over and sign. You might be able to run down to the DHCR and say to them, look, I'm going to be the tenant of this apartment. I want to see the rent history. I honestly don't know whether they will give it or not to a prospective tenant. I've never seen that situation. So the answer is generally you got to move in, then request the rent history, then take it to an attorney to analyze whether you have a claim that the apartment was improperly deregulated and that you, in fact, are rent stabilized, which, by the way, has become a huge part of our practice since the passage of HISPA.
Right. Yeah. Sam, I know we set aside 30 minutes for this Q&A and time has flown by, but I think it might be interesting for our audience just to hear about what kind of issues you're dealing with in your practice right now.
Yeah.
Is there something you can share?
Yeah. So the illegal deregulation cases are huge. We get inquiries from many tenants who come to us and say, I think my apartment should be stabilized. I got this rent history. And, it's impossible for me to summarize the law here because there are a lot of issues about how far back you can go and what the statute of limitations is and what kind of overcharges you might be entitled to. The good thing is that there is no statute of limitations if you bring a case and you're challenging the status. In other words, you're saying, it's not so much an issue of the rent I'm paying. I just want to see if I'm stabilized. But the courts and HISPA actually extended the statute of limitations on rent overcharges to 6 years. The issues come up is what happens when the deregulation took place 15 years ago. You have a tenant who was living, the last rent stabilized tenant supposedly was living in the apartment in 2005, was paying $1,000 a month. The next tenant, it says the apartment was destabilized. Will the courts allow you to go back that far and challenge that? And pretty much the recent holdings have said, unless you can establish fraud, you can't do that. And there have been some recent appellate decisions that have been bad for our side. But that is still a rather large part of our practice. And some of those cases are in Supreme Court, some are in housing court, some are at the DHCR. The other common situation we're seeing are, especially during the pandemic, were lease breach cases. Suddenly people were thrown out of work, they had no income, they moved out of their apartments, or they stayed and they stopped paying rent because they had no income. At first, we tried to argue that the pandemic was what the law calls a force majeure event, similar to a hurricane or a flood. Those arguments were slapped down, both in the commercial and residential context. But we did get a lot of lease breach cases, both in the terms of where people were still in the apartments and where people had left. And we also get a lot of cases where people move into an apartment and it's in terrible shape. And they want to know, are the conditions bad enough for us to be able to leave and break the lease? And that really depends on how bad the conditions are. If there's a couple of mice and roaches, that's probably not going to do it. On the other hand, if, the entire apartment is leaking and flooding and there's problems with the heat and hot water, that'll probably be enough. What we've seen a drastic drop off in is non-primary residence cases. That used to be the number one case in the firm. Those are almost gone for the same reason that you don't see buyouts. Why would a landlord spend, tens of thousands of dollars on a lawyer to get possession of an apartment that they could only raise the rent $89? So you don't see those. And what we're finding is that landlords are much more willing to grant succession to tenants for the same reason. If they fight it and they get the apartment back, what do they gain? So we're finding that succession cases, which used to be a huge part of the practice, now all it involves sometimes is writing a letter providing some proof that, the tenant has succession rights, and the landlords, for the most part, are not contesting them with a court fight.
Interesting. Yeah. So it is now much harder for landlords to deregulate these apartments, and that's having a trickle down. Well, listen, Sam, thank you so much for sharing all this information, and thank you for everyone for coming to our Q&A. We will post this recording online, so you can feel free to share this with anyone you think will be interested. Like, subscribe, and comment. I'd point out again that Brick Underground also has lots of articles on every aspect of renting, whether you're looking for a place or you want to find out if your rent's stabilised. We also have market reports, which are a temperature check on the market and give you information about how much leverage you have in negotiating the rent when you sign the lease or at renewal time. And of course, the latest data does put landlords very much in control, but there are still protections for tenants. And we're here to empower you with that knowledge. So please do head to brickunderground.com. Big thank you, Sam. Thank you very much to Sam Himmelstein of Himmelstein, McConnell, Gribben Joseph. Please do find him online and subscribe to our newsletter at brickunderground.com. And yeah, thank you very much for joining us.
Thanks for having me. I appreciate it.
All the best. Thank you, Sam.